All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Court now calls case number CV130763, Ahern versus Levitt. This is the time set for oral argument. Counsel, I'll advise you that these proceedings are being audio and video recorded, and there will be a link to these proceedings within a few days after the hearing today if you wish to view that. When you stand up to make your oral argument, if you would, please identify yourself and your client. Each side has 20 minutes. Appellants may reserve time for rebuttal. You have a clock in front of you to keep track of your time. As you well know, we have discussed the case, we've read the briefs, so we're very familiar with the issues in the case. That being said, counsel for the appellant, Mr. Levine.
May it please the court, my name is Jack Levine, and I represent the appellant, Linda Levitt, in this matter. And it's my privilege to address the court on issues that I believe are terribly important to an understanding of our community property laws, and also the fact that apparently from the decision of the trial court in this matter, there is a lot of confusion in the lower courts about the proper standard to apply when one spouse obtains community property from the other spouse without proving by clear and convincing evidence that there was no fraud, undue influence, or mistake, and that the spouse that is giving up their interest in the community property had an opportunity to confer with legal counsel concerning his or her rights. Now, the concepts...
Are you saying, Mr. Levine, that a disclaimer deed is like a postnuptial agreement?
That it is like a postnuptial agreement?
Saying it is a postnuptial agreement or like a postnuptial agreement?
Well, I'm not...
Because I think our cases seem to make a distinction between what a postnuptial agreement may be and what a disclaimer deed is.
Well, I think they're distinct transactions. A disclaimer deed is reserved for one spouse acquiring sole and separate property in his or her own name, with the other member of the community disclaiming any interest in that property to make it clear that the spouse acquiring that sole and separate property is sole and separate property to that spouse. That's what a disclaimer deed is, I believe, is intended to accomplish.
Well, at least we've seen them where parties want to refinance a home. One party has bad credit, disclaims the interest. They proceed on at some point in time, and ultimately the issue becomes whether it should have been done, but whether or not the party that disclaimed had an equitable interest. This is a twist on that, but there's no one universal rule, at least as we've seen disclaimer deeds being used by litigants.
Okay. Well, I'll concede that, Your Honor, that there may not be one universal rule, but there is one universal rule, and that is that husband and wife occupy a fiduciary relationship to each other, and they should not be dealing with community property by fraud, undue influence, or by mistake on the part of the spouse that's giving up their right to the community property. That's what I'm saying.
Okay. But then it gets back to at least where you started and where the briefs start on who has the burden of proof. Because in a disclaimer deed, traditionally, if one party is saying the other party got them to do it, then the party complaining has the burden of proving the 9 elements of fraud or the mistake of fact or something. And you're saying, at least as I understand the briefing, that it was, in this case, husband's responsibility to prove that he didn't do those things.
not only that he didn't do it, but he must prove that by clear and convincing evidence. Now, Your Honor.
So you would, as a former criminal defense attorney of mine, say he's got to disprove a negative.
He's got to prove a negative, I think, but
Okay.
yeah, he's got to prove that he didn't do that.
Okay.
Okay? Now, these concepts go back many centuries to the time when the husband was presumed to be the legal, the spokesman for the community. He was the only one who could act for the community. He was the only one who could convey.
He's the only one who could own land.
Well, that's right. That's right.
Okay, if you want to go
But
back, that's why people did that.
Okay, but we've got away from those days.
Thankfully.
And we're now in an era where legally there's a presumption that both spouses are equal under the law. But as a practical matter, both physically and emotionally, they may not be equal. There are many instances where the wife is submissive, where she is weak, where the husband is aggressive and strong, where he dominates the relationship, and vice versa. There could be situations where the wife is emotionally strong and dominates the relationship. And so it could go either way, and that's why the law has settled, I submit, on this principle that whoever is getting the benefit of any conveyance of community property to the other spouse as his or her sole and separate property, the party who gets the benefit has to prove by clear and convincing evidence that it was done fairly, without fraud, without undue influence, and that there was no mistake. That's the whole issue in this case. Now, the appellee, in filing I don't know.
At least the court didn't think there was fraud, and the court heard the testimony of both parties.
Well, that's correct. That's correct.
But so did the trial court just need to say that, based upon the testimony, husband has met his burden of proof by clear and convincing evidence that there wasn't fraud, mistake or abuse?
No. What the trial court said, Your Honor,
I know what they said, but I'm trying to understand what you think the trial court needed to say.
I think what the trial court needed to say was that the husband, that the appellee did not prove first of all, the burden of proof was on the appellee, not on my client. And that's one serious error that I believe the court made. And the other serious error was that the husband, the appellee, did not prove by clear and convincing evidence that there was no fraud or undue influence or mistake. They needed to do that. They needed to carry the burden of proof on this issue. The court got this entirely reversed. And that's how the court came out with their decision that my client hadn't carried her burden of proof of fraud and undue influence.
Mr. Levine, whatever the burden of proof is, did not the trial court disregard your client's testimony as not credible?
Well, that's what the judge said in her decision. Now, I don't know why it wasn't credible. The credibility of witnesses is up to the juries and to the judge if it's a non-jury trial. But if the court had viewed this in the proper perspective, requiring the husband to prove by clear and convincing evidence that there was no fraud or undue influence, I don't think the court would have come out the way it did. And that's why we're here, because there was a wrong burden of proof applied. And the other reason is that the court felt that the Bill Kilburn case applied to this set of circumstances rather than the In re Harbor case. And most of the judges, I wouldn't say most of the judges, this judge apparently confused the two cases in this regard. In Bill Kilburn, there was an acquisition by the community, there was an acquisition by one of the parties to a community of sole and separate property. And the wife was acquiring the property. She asked the husband to sign a disclaimer deed, and which is the proper thing to do because it disclaims any interest that the spouse has to the property that is being acquired by the other spouse. And so that was the In re Harbor case. The Bill Kilburn, the property being acquired was property that property was being acquired by one spouse. Well, that property was sole and separate property that was being acquired, by the other spouse. In In re Harbor, the property being acquired was community property. In other words, the property being acquired was property that was. I'm a little confused about this. In one case, in Bill Kilburn, the issue was, can sole and separate property be acquired by a disclaimer deed, and in the other case, it was, can one spouse to a marriage give up their right to community property? In other words, one was community property, one was sole and separate property at the time it was acquired. That's a distinction. That's an important distinction. Because when a community is acquiring sole and separate property, or when two parties to a community are acquiring sole and separate property, there's no loss by not proving by clear and convincing evidence that there was fraud, that there was no fraud or undue influence. So in one case, it was community property that was being acquired, or it was community property that was being conveyed. In the other case, it was sole and separate property that was being acquired. I'm sure I confused that. I probably confused the court, but the two cases revolve around whether it was sole and separate property that was being disclaimed or whether it was community property that was being disclaimed. That's the issue. That's the difference between the Bill Kilburn and the In re Harbor. So with that, I'll sit down.
All right. Thank you, Mr. Levine. Ms. Hamilton?
Thank you, Your Honor.
May it please the Court, my name is Christina Hamilton, and I represent Kevin Ahern, the appellee. This appeal must be denied for so many very clear reasons. Number one, Judge Brnovich clearly applied Arizona law. There are 3 Arizona reported cases that say if during a marriage a spouse signs a disclaimer deed, then the deed is binding absent a demonstration of fraud or mistake. And Judge Brnovich applied that case, those 3 cases, to reach her decision. All 3 say that the deed in and of itself rebuts the presumption of community property, which then shifts the burden to the spouse wanting to upset the deed to show fraud or mistake. In the instant case, I want to remind this Court that the only premise at the underlying trial level to set aside the deed was wife's claim of fraud. There was no claim of mistake, there was no claim of undue influence, there was nothing. So that was the only basis that she moved to set aside the deed. Not only did Judge Brnovich apply the Arizona existing law, but the comments about ARS Section 25-214 and some of the mistake and undue influence things that are now raised in the appellate briefs were never raised below. Wife totally disregards that the judge...
So the only thing was the fraud about unmarried man?
Your Honor, that unmarried man comment comes in 2006, 5 years after the deed was signed.
Right,
So
but
yes, there was some bank paperwork later on, but had nothing to do with the transaction between the spouses.
But I'm trying to understand the difference between what was raised in the trial court and what was raised here.
Okay.
Because didn't you just say that there's
They didn't
new
raise...
stuff here?
They raised the issue of fraud. They said husband defrauded wife by causing her to sign the deed.
Is that different than undue influence?
Well, I'm not sure undue influence is even a factor under Bell-Kilbourne because it says fraud or mistake. It doesn't really say undue influence. But even if it were, then wife's claim below, as set forth in her pretrial statement, was whether or not husband had defrauded her in getting her to sign the deed. That was what she claimed. The judge totally listened.
What was the fraud supposed to consist of? I mean, I'm aware of an assertion that he stated that he was an unmarried man, but he wasn't.
But that was in 2006, 5 years after the deed was
So
signed.
was there some other basis for this, for the fraud claim?
From what I gather, the fraud claim was that she, it was kind of a crazy thing, but that she didn't understand what a deed was because she's a teacher and she thought a deed was like a good deed, that she didn't understand that the property in question was the marital residence because the deed had the word Coronado on there, and so she claimed she thought that was some property in Coronado, and that then at the time husband gave her the check, because she agrees she voluntarily signed the deed, but at the time he gave her the check for her interest in the property, she has a very dramatic story about him threatening her that if she doesn't sign the check, that she will either lose custody of their common child or something terrible would happen to her child.
I guess I'm still having trouble understanding that as fraud. That sounds like something else. But fraud is basically an affirmative misrepresentation that causes the other person to do something disadvantageous.
I agree, Your Honor. And but I'm just articulating what I understood was articulated below. And under Bell-Kilbourne, it doesn't say undue influence, it says fraud. That was the basis, or mistake. So that's what was presented below. Wife also just totally ignores the fact that on the other three properties that are at issue, that's Caitlin's house, the Tempe Townhouse, and the 1144 partnership, Judge Brnovich made independent findings on those three assets as to why they were my client's separate property or were non-marital property. In Caitlin's case, the property had been transferred long ago to an irrevocable trust, and the judge found that there was not only factual testimony to support that, but that there was an expert who testified that the trust was irrevocable, and therefore the property was outside the marital estate. And finally, no matter what burden and whose burden it was, Judge Brnovich made repetitive and very clear comments that she did not find wife's assertions credible. She said, wife has failed to show any credible evidence of fraud. Wife's testimony regarding the circumstances of signing and the payment of money was not credible. And then later, she found, she didn't just say it wasn't credible, she said it was unreasonable. And she said the single biggest issue in the case and the single largest cause for expense was wife's argument that the 2001 disclaimer deed for the 6618 house should be set aside for fraud. While the fraud claim was the subject of a dramatic and vitriolic argument, wife's actual evidence of fraud at trial was non-existent, and her claim was actually directly contradicted by both the testimony and documentary evidence. So the whole comment that you were talking about with Mr. Levine about, well, okay, if we shift the burden, doesn't it come out to be the same? It does. There was no demonstration of fraud.
Well, what's the difference between a post-nuptial agreement and a disclaimer deed?
Sure. So in a disclaimer deed, specifically as in what happened in Bell-Kilbourne and Bender and Rubenstein, the parties at that time are transacting to transfer property. They're saying, for whatever reason, I'm giving up my interest in that property. And in this particular case, there was consideration for giving up her interest in that property that she accepted.
Isn't the difference that one's an agreement and the other is transfer of property?
Well, I think that's part of it, but I mean, a deed is a contract as well, so.
It might involve agreements and contracts, but you can
It's a transfer device, exactly.
gift by devise.
Absolutely, right. And the Harbor case talks about a prospective application of the laws of Arizona as it will relate to the marriage, like whether we're going to disband community property laws, for example, as on the marriage. That's not what happened here. And in Rubenstein versus Sela, the court says, look, if it's an executed contract and you've performed, i.e. you paid for your interest in the property, it's not for the court to undo that voluntary act. You made your deal, you have to live by your deal. And in fact, in this case, she did live by the deal for over a decade and kept the money as her own and reinvested the money as her own, and obviously knew husband was doing transactions using the property as the source of getting financing to do other ventures. So she knew all along, and she treated the property as her separate property all along, and only when we get to the divorce does she now say, oh, I don't want to live by that deal anymore, and I want my half of the house. The evidence was clear at trial. She had had the opportunity to meet with attorneys. Husband had encouraged her to meet with attorneys. She said she had been, quote, advised, close quote, before she signed the deed not to allow any financing on the house, and so she had obviously been meeting with an attorney. She never dispelled any of that at trial. She never dispelled or even questioned at trial how the amount of the consideration was calculated. There was no testimony about that other than husbands who had said, here's exactly how we got there. She owned a sixth of the property because of each of our separate property investments. I gave her that back. I gave her interest on her investment, and I gave her 1/6 of the appreciation. Wife never said, oh, I found that unfair. The most interesting thing is wife's big claim is that it wasn't at the time of the deed. She acknowledges she went down and signed that deed voluntarily. Her claim is that when husband gave her the check, somehow she was forced to sign the back of the check, and that's where the fraud happened. But that makes no sense, because somebody could sign, even if that was happening and she signs the check, at this time she says she's under pressure, no one says she had to deposit it. No one said she couldn't just rip it up. No one said she couldn't go to the lawyer the next day and say, hey, I don't want to be bought out of my property, let's do something. She didn't do any of that. She deposited the check, and on went life. She also knew about the deed repetitively through the course of the marriage and went to see lawyers repetitively after the signing of the deed through the course of the marriage, and that's not disputed. And in fact, in 2006, there was an incident at the house where husband punched out a screen in the house. Wife had him arrested. The case was dismissed, and wife knew that because the motion came from the prosecutor, because the house was deemed to be the exclusive property of husband at that date. Also in 2006, there was a previous divorce action file. Wife has testified. She went down and read the file. The file said the house is husband's. So her sitting back and doing nothing for over a decade, not only was there no fraud at the instigation, but clearly statute of limitations, estoppel, laches, which are all the things that the cases say could apply in this instant case, applied. She got the benefit of her bargain. She kept the benefit of her bargain. And now only when there's a divorce does she want to say, oh, let's do that over again, which Rubenstein versus Sela says is not allowed. The 25-214 claim that was first raised in the appellate level, 25-214 is to protect a spouse from one spouse during the marriage transferring property outside the marital community. It has nothing to do with one spouse agreeing to transfer property to another spouse. The three cases that we've talked about, I'm sorry.
Does it say that in the statute?
It just says to bind the community, you have to transfer it that way. You're not binding the community if one spouse is saying, I'm divesting myself of my interest in that property, whatever it may be, and giving it to you. That's a totally different thing. And obviously all the case law under 25-214 is very clear that it's to protect the community from one spouse acting as a rogue and doing something that the other spouse was unaware of.
But does one of these cases specifically say that statute does not apply to transfer from one spouse to another?
Okay, none of those, no, I don't have a case that says that in specific, but Binder, Bell-Kilbourne, Rubenstein versus Sela, and another case, Jones versus Rigdon, all talk about deeds between spouses where one spouse signed off and it got transferred to the other, and no one ever said, hey, wait a minute, there was supposed to be two signatures on those deeds. In fact, I found no cases nor any pro formas of deeds that have ever been, used as a form that are somehow supposed to be for both spouses to sign to transfer to one spouse. The comment that Mr. Levine made that there's a difference between the cases, whether it was acquired with separate property or whether it was acquired with community property, and that's somehow a distinction of why Bell-Kilbourne should or should not apply, was specifically addressed in the Bell-Kilbourne case. And the Bell-Kilbourne case says, we don't care how it was acquired. It says, second, husband is incorrect in stating the Bender decision rested in the character of the funds used to purchase the trailer park. The court did not discuss whether separate property or community funds were used to purchase the park. Rather, the Bender court grounded its decision in the existence of the disclaimer deed as rebutting the presumption that the park was community property as it was acquired during the parties' marriage. So what they say is, we don't care what the source is. Once you've signed the deed, you have rebutted the presumption. And now the burden transfers to the spouse trying to set that aside to prove fraud or mistake. In addition to the fact that the Caitlin's house was already in an irrevocable trust, and that was an independent basis to affirm that that was non-marital property, which Judge Brnovich said. So that means whether or not the deed on the 6618 house is valid or not, that house was independently found to be non-marital property. With regard to the Tempe house that was the condominium, that was held in an LLC, the 6618 LLC, and Judge Brnovich, in paragraph 15 of the decree, specifically said, for other reasons, wife, you're getting these LLCs, husband, you're getting these LLCs, which includes the 6618 LLC, and wife, you're getting an obligation that you owe to the LLC, you're getting it waived, essentially. And then Judge said, so now 6618 is husband's. And 6618 then goes out and buys this Tempe condominium. So again, there's a reason independent of the 6618 house for affirming that as a separate property.
That's essentially an equitable division of the community assets, irrespective of whatever else may have happened.
Yeah. And then finally, on the 1144 partnership, the judge found that he put $25,000 in, that he got a line of credit against his house to get the $25,000, but that the $25,000 had all been paid back from distributions from the partnership. The court also found that on Caitlin's house, there had been a $125,000 line of credit. It was paid down to $93,000 at the time of the trial. And the judge said, yeah, you're going to pay wife back for that community lien. And husband did pay her back for that difference between 125 and 93. There was no evidence provided on either of the other two properties that there had been some pay down by the community for which the community would have a lien. There was nothing about that. Finally, Your Honor, the question about the attorney's fees, sorry.
My apologies.
In the joint pretrial statement, wife's claim was, I want husband to pay any attorney's fees of mine over and above $100,000. That was her claim. So then when it came to making a fee application, her total fees were $120,000. So the whole of the issue was limited to $20,000 because wife had put in her pretrial, I only want anything over and above $100,000. The judge gave wife $10,000 toward that differential. The judge also set forth 9 very lengthy and specific paragraphs of unreasonable behavior of wife that had been rampant throughout the pendency of the proceedings.
Was part of the reason that the judge awarded the lower amount, the statement in the pretrial?
I mean, it doesn't say that in the decree per se, but that is exactly what they asked for. They said anything over $100,000.
But at least
and then the judge said,
on the face of it, the judge's ruling was based on the 324 factors.
right, the judge said, went through a very long dissertation of the unreasonableness of the positions that wife had taken, and then she basically said, but at the end of the day, husband makes more money than wife does, and so for that reason, I'm going to give her a very small amount. And she says, however, the amount will not be significant based on wife's behavior. So for them to now come in and suggest that they should gotten 100, oh, I'm sorry, on page 11 of the decree, paragraph 29, attorney's fees and costs, it says, clearly husband is the party with the greater financial resources, and therefore under ARS 25324 could be ordered to pay all or part of wife's attorney's fees above $100,000. So it is specifically in there.
So it's a reference to the pretrial statement.
Yes.
So does it appear that the trial judge was only considering amounts in excess of 100,000?
Well, that's what the request was, and so her language is, can I order any of the fees over and above $100,000, which I think comes from the claim that wife was making in her pretrial statement. And I remind the court of the Leathers decision where you've all told us that you're locked into what you put in the pretrial statement, so you can't.
I told you.
Okay. You can't tell us you want something different during the trial. You're locked into what you asked for in the pretrial statement, and that's what we went to litigate.
Oh, consistency is the hobgoblin of little minds.
Isn't it,
Come
though?
on.
One of those little minds.
So, Your Honors, there's no law that supports their position. More to the point, all of the facts of which you're supposed to affirm the trial court, unless there's been an abuse of discretion, are well documented in this very lengthy decree that walks through every single one of wife's claims, walks through every single property, and says, look, wife's evidence was not credible. It defied the testimony, it defied the documentary evidence, it defied what she'd put in her motion for summary judgment affidavits, it defied what she said in her deposition as opposed to trial, and none of it made sense, because again, if she really didn't want the money, she didn't have to deposit the check. They didn't do it at the bank, they did it at their house, she didn't have to deposit the check. She did. She invested it from $118,000 to $238,000 over the course of the marriage. She took the money in June of 2012, I believe, and it was not listed as community property on her resolution management conference statement. So for all of the above reasons, I believe that she is held to her voluntary act of signing the decree, or I'm sorry, signing the deed per the Rubenstein case, and therefore the ruling of Judge Brnovich should be upheld. Thank you.
Thank you, counsel. Mr. Levine, rebuttal?
Yes, thank you, Your Honors, I have figured out exactly what I was trying to say earlier, and that is Bill Kilburn stands for the proposition that it's okay to acquire separate property without the heavy burden of proof on the part of the person who is acquiring the property, and as opposed to a state of harbor, which says it's not okay if the community gives up, if one member of the community gives up their rights to the other spouse in connection with property that's community property. In other words, one deals with community property, one deals with separate property. And that's the distinction between the two cases. Now, the consideration for the disclaimer deed, there was no consideration given at the time the disclaimer deed was signed. The husband merely said, sign this. Didn't offer any consideration for her doing that. It wasn't until months later that he came to her and thrust this check upon her, and even then, it was not negotiated. The client, my client didn't have an opportunity to say, no, that's not enough. This was a property that my wife estimated was worth $800,000, and she was given a check for $100 and some odd thousand as her interest in the community property on that house. So I think that explains those circumstances. Now, the attorney fees, husband, I think, is trying to confuse the issue on the amount of the attorney's fees. In the pretrial statement, you'll find on page 14, it says, Linda to be awarded $80,000 in attorney's fees out of Kevin's share of the community property. there were statements made and there was testimony at the trial that the attorney fees were over $100,000. So she was asking for to be reimbursed for attorney's fees of over $100,000, not anything over $100,000, but attorney's fees of over $100,000. That's where there was a semantical difference here. So I wanted the court to be aware of that. But in my final closing and my final remarks is that there needs to be a clear distinction between conveyances of community property where a spouse is acquiring separate property as opposed to a spouse acquiring community property. There's a big difference there.
As I understand, both of these parties had houses that were their sole and separate property prior to the marriage.
Correct.
So if they had individually sold those properties and used the proceeds from those sales to buy new properties, wouldn't those automatically remain, you could follow the money so they remain sole and separate without needing a disclaimer deed?
Well, Your Honor, I believe there's a presumption that when two spouses marry and they put money or property into the marriage, that there's a presumption that that was a gift to the community.
Well, but I'm just saying they had their properties. They were paid off under my hypothetical. They got married. Then the day or the week afterwards, each of them sold their property and then bought new property, raw investment land or ski resort or whatever the case may be. Couldn't you just follow the money and find that the new purchases were sold and separate in spite of the presumption of community, because they had sold property, they used sold monies to buy new property, and they remain sole properties?
Well, yeah, it depends on how much weight you want to give to the principle of equitable distribution of community property and how much weight you want to give to the presumption that when two spouses join together and they put everything in a pot, then the pot belongs to the community.
There may be some equitable interest that each of them have based upon any community, because we've seen lots of those cases where one party disclaims an interest, but community still is paying on the mortgage. And so there's an equitable, issue that has to be resolved. Okay,
Yeah.
we'll wrestle with this.
It gets very complicated when you start talking about mortgage payments and maintenance to the house that has been acquired by individual contributions, to the community. It gets very complicated. This was an 18-year marriage. They lived in this house, I think, for over 15 years. So that's a considerable, maybe 16 years. That was a considerable period of time. And during that period of time, the community was certainly contributing heavily to the maintenance of that house. But when you get right down to it, Your Honors, if you examine the burden of proof that is required when one spouse is being required to give up their rights to community property, as opposed to one spouse acquiring separate property and wanting a disclaimer deed to show that that separate property that that spouse is acquiring is his sole and separate property and does not belong to the community. That's the purpose for a disclaimer deed, to rebut the presumption that it's community property. So I'd like you to keep that thought in mind. Thank you.
Thank you, counsel, for your arguments this morning. We'll take this matter under advisement and we'll issue a written decision. Court's in recess.